Unit 22 Redressal of Public Grievances. In the contemporary society, state plays an important role in the socio-economic development. The success of democracy and development depends to a greater extent on the efficiency of the government machinery. However, in the exercise of administrative powers, there is always a possibility of malpractices. This results in public grievances towards the administration. According to Chambers' dictionary, grievances means a ground of complaint, a condition felt to be oppressive or wrongful. In a democracy, people should have the opportunities to ventilate their grievances and a system of redressal. In this unit, we shall be discussing the nature of public grievances and the institutional arrangements for the redressal of the same. Public grievances. The colonial history and the authoritarian orientation of Indian administration resulted in the negative attitude of citizens towards the administration. The gap between the performance of administration and the expectations of the people also created a negative image of administration. The democratic aspirations of the people and authoritarian attitude of administrators produced tensions between the two. The contradictions in the social situation have resulted in inequalities. There is discrimination in the treatment of citizens by administration. The social gap between the civil servant and the citizen whom he is expected to serve also is a cause for hostile relationship between the two. The well-educated urban middle-class civil servant is expected to serve the poor and illiterate rural citizens. This creates a socio-psychological gap between them. Then there are chronic delays in getting things done. The innumerable rules and regulations that are not easily comprehensible to ordinary citizens. The cumulative effect of all these factors is the piling up of public grievances against administration. Some of the common grievances against administration may be listed here. Number 1, corruption. Demand and acceptance of bribery for doing or not doing things. Number 2, favoritism. Doing or not doing things for obliging people in power or people who matter. Third, nepotism. Helping the people of one's own kith or kin. Discourtesy. Use of abusive language or other type of misbehavior. Neglect of duty, not doing things that the law requires. 6. Discrimination. Ignoring poor and uninfluential citizens, genuine complaints. Delay, not doing things at the appropriate time. Maladministration, inefficiency in achieving the targets. Inadequate redressal machinery, failure to attend to public complaints against administration. In addition to the above mentioned common grievances, there may be specific grievances relating to particular administrative departments, agencies. For example, people have many grievances against the police, resorting to third-degree methods like beating, torturing, wrongful confinement, or harassment of suspects and witnesses. Fabrication of evidences, nexus between the police and the underworld are some other areas of public grievances against police administration. The grievances against agriculture administration may be mainly related to quality and quantity of inputs and services provided to farmers, though there may be many specific grievances against individual administration agencies. Corruption is the most common among them all. We shall be discussing the public grievances pertaining to corruption along with the machinery for the redressal of the same in the ensuing sections. Corruption in administration. Everyone who comes in contact with administration feels the all-pervading nature of corruption. Corruption may corruption has many negative effects on administration. It is one of the impartiality suffered due to this factor. There is loss of credibility of administration, and it is the poor man who suffers most because of it. Modes of corruption. The corruption has been defined in many ways. In general, term corruption is not always for monetary gains. It is the personal use of public office in violation of rules and regulations. Sri Santhanam, chairperson of the Committee on Prevention of Corruption, said, any action or failure to take action in the performance of duty by a government servant for some advantage is corruption. The Central Vigilance Commission has identified the following modes of corruption. Number 1. Acceptance of substandard stores works. Number 2. Misappropriation of public money and stores. Borrowing of money from contractors, firms having official dealing with officers. Show of favors to contractors and firms. Possession of assets disproportionate to income. Purchase of immovable property without prior permission or intimation. Losses to the government by negligence or otherwise. Abuse of official position, power. Production of forged certificate of age, birth, community. Irregularities in reservation of seats by rail or by air. Institutions for dealing with corruption. There are various institutions in India for dealing with corruption. The Central Vigilance Commission is one among them. We will be dealing with the functions of the CVC in the following paragraphs. Central Vigilance Commission (CVC). After independence, various measures were taken up for checking corruption in public services. In 1962, the central government appointed a Committee on Prevention of Corruption under the chairmanship of Sri K. Santhanam to review the existing arrangements for checking corruption and to suggest steps to make anti-corruption measures more effective. The Santhanam Committee in 1964 recommended the setting up of Central Vigilance Commission headed by Central Vigilance Commissioner. Based on the committee's recommendations, the Central Vigilance Commission was constituted in 1964. The role of the commission is advisory. It falls within the jurisdiction of Ministry of Personnel. Its jurisdiction and powers extends to all those matters which fall within the purview of the executing officer. Executive powers of the central government. Its jurisdiction covers: number 1, all the employees of the central government. Number 2, all the employees of public undertakings, corporate bodies and other institutions under the central government. All the employees of the Delhi Metropolitan Council and the New Delhi Municipal Corporation. The Commission receives complaints against corruption and malpractices directly from the aggrieved citizens. It can also gather information about the same from press reports, audit reports, various departments, enterprises concerned, allegations made by members of parliament and reports of parliamentary committee. It is headed by Central Vigilance Commissioner, who is appointed by the President of India for a period of 6 years or till the age of 65 years, whichever is earlier. He can be removed in the same manner as provided for the removal of the chairman of UPSC. He is not eligible for any further employment either under the central government or the state government. The functions of the CVC are: number 1, undertaking inquiry into any transaction in which a public servant is suspected or alleged to have acted for an improper purpose or in a corrupt manner and tendering advice to the disciplinary authorities. Such cases at a different stage of investigation, appeal and review. Second, exercising a general check and supervision on the vigilance and anti-corruption work in ministries and departments of the GOI and other autonomous bodies. Third, advising the administrative authorities to modify the existing procedures and practices when it appears that such procedures and practices afford scope for corruption and misconduct. Approving the appointment of chief vigilance officers who head the vigilance units in various organizations. It may initiate a review of procedures and practices of administration insofar as they relate to maintenance of integrity in administration. Vigilance machinery in the states and districts. The vigilance machinery at the state level differs from the state to state. Most of the states have a state vigilance commission. There is also a special police establishment to deal with cases of corruption in both the state government and the state public undertakings. The commission presents annual report to the state government and the same is placed before the state legislature. At the district level, there is a district vigilance officer. The district collector appoints one of his gazetted officer as district vigilance officer, Lokpal. The Administrative Reforms Commission (ARC), which was constituted in 1966, gave priority to the problem of redressal of public grievances and submitted its first interim report on the problems of redressal of citizen grievances. The ARC recommended the creation of ombudsman type institution, namely the Lokpal and Lokayukta. The Scandinavian institution of ombudsman is the earliest institution for the redressal of public grievances, first established in Sweden in 1809. The ombudsman institution is based on the principle of administrative accountability in parliament. The institution refers to an officer appointed by the legislature to handle complaints against administrative and judicial action. The features of these institutions are given by ARC are: number 1, they should be demonstrably independent and impartial. Their investigations and proceedings should be conducted in private and should be uniform in character. Their appointment should as far as possible be non-political. Their status should compare with highest judicial functionary in the country. They should deal with matters in the discretionary field involving acts of injustice, corruption and favoritism. Their proceedings should not be subjected to judicial interferences, and they should have a maximum latitude and powers in obtaining information relevant to their duties, and they should not look forward to any benefit or pecuniary advantages from the executive government. Based on the recommendations of ARC, many attempts were made from 1968 onward for the establishment of Lokpal at the central level. The Government of India introduced bills for this purpose in the Parliament in 1968, 1977, 1985, 1990, 1998 and the latest being in 2001. The Lokpal Bill introduced in 1977 brought the Prime Minister as well as members of Parliament under its purview, while the 1985 Bill excluded the Prime Minister from the jurisdiction of Lokpal. The Bill on Lokpal introduced in Parliament recently has brought in Prime Minister again under Lokpal's jurisdiction. Unfortunately, these bills could not be passed by Parliament. Lokayukta. The Ombudsman established at the level of states in India is known as the Lokayukta. Many state governments have established the office of the Lokayukta and Up-Lokayukta. The office of the Lokayukta exists in Maharashtra, Bihar, Uttar Pradesh, Madhya Pradesh, Andhra Pradesh, Himachal Pradesh, Karnataka, Assam, Gujarat, Punjab, Delhi and Haryana. Kerala is also in a process of establishing this office. Orissa was the first state to pass ombudsman legislation in 1970 and also the first to abolish the institution in 1993. Appointment. The appointment of the Lokayukta and Up-Lokayukta is made by the governor, who is the executive head in the states. The Lokayukta Acts provide that the governor shall appoint Lokayukta, Up-Lokayukta in consultation with the Chief Justice of the High Court of the state and the leader of the opposition in the Legislative Assembly. Terms and conditions of office. The term of the Lokayukta and Up-Lokayukta has been fixed for 5 years. The Assam Act, however, prescribes an upper age limit of 68 years. The status prescribed for the Lokayukta is equal to that of Chief Justice of High Court or Judge of the Supreme Court of India, and that of Up-Lokayukta to the Judge of a High Court, and in any case to an additional secretary to the Government of India. With a view to ensure independence and impartiality, the Lokayukta, Up-Lokayukta have been debarred from being a member of parliament or a state legislature and prohibited from keeping any connection with political parties. After relinquishing office, they have been made ineligible to hold another office under their respective state governments. All acts expressly prohibit the reappointment of the Lokayuktas. The Lokayukta and Up-Lokayukta can be removed from office by the governor for misbehavior or incapacity. The procedure prescribed for the removal of the Lokayukta is almost the same as provided for in the Constitution of India for the removal of judges of the High Court or the Supreme Court jurisdiction. The Lokayukta and Up-Lokayukta has been granted powers to investigate any action which is taken by or with the general or specific approval of a minister or a secretary or any other public servant. Thus, all administrative actions from the level of ministers to the lower levels are subjected to scrutiny by the Lokayukta and Up-Lokayukta. Certain other categories of officials like chairman of Jila Parishad and other local bodies have also been included within the purview of Lokayukta. Procedure of investigation. After making preliminary investigation where the Lokayukta or Up-Lokayukta proposes to conduct investigation, he forwards a copy of the complaint to the officer and to the competent authority concerned. Any proceedings before the Lokayukta and Up-Lokayukta has to be conducted in private, and the identity of the complainant or the person complained against is not to be disclosed at any stage of investigation. Summary. The interaction between the citizen and administration in a democracy is a very complex process. The conflict in the society and the values of the society are reflected in this interaction. The effective machinery for the redressal of citizens' grievances makes the administration more human and civilized. In this unit, an attempt was made to study of public grievances with specific reference to corruption and existing machinery for the redressal.